All right.
And Your Honor, Aaron Winkles appearing on behalf of Byron Frazier.
Thank you. Interpreter would just identify herself, please, and what she's interpreting.
Again, Connor, I'm Washington State Court certified ASL.
All right, so this one matter comes on for a presentation of order. There were no objections. So Ms. Winkles.
Yes, Your Honor. I believe Ms. Makupe has had a copy of these are final orders as the parties agreed to everything but summer vacation. We have made that change for Ms. Makupe to 2 weeks. She's here on the record. I'm assuming she's going to agree to your signing those orders.
So with that, have you had an opportunity to review the orders?
The one she sent me yesterday?
Yes.
Yes, I did. I don't mind the 2 weeks, that's fine. The thing is, it showed on there every 3-day weekend. Easter is on a Sunday, and it doesn't show in that order that for that holiday. And so she would always be with him, since she's on with him on Sunday. I'd like to have her on Easter, like at least every other year.
And I believe she does on the spring break. I believe this covers the Easter. The 3-day holidays are not the named holidays.
But Easter changes every year, so it's not always on spring break.
And Your Honor, you can internally agree to that. Every other year on Easter.
Hold on, I've got to write it in. Let's see. Ms. Winkles, I would rather have a clean order.
Okay.
Can you go ahead and add Easter alternating?
Absolutely, Your Honor.
Okay. And there was something else?
Yeah, so I'm trying to think what it was. And with, it said in the papers, the child needs to go to that direct parent if they have any issues or whatever. I agree with that, but it just from past things, she has asked me to go with her. And why she's, because I tell her to go talk to her dad about it. And she's scared that he'll get mad at her. So she doesn't discuss it with him.
I can delete that, Your Honor. That's just under section 14.
Okay. She'll delete that.
Okay. And for, I've seen it for like school activities and stuff like that. But she also plays softball out of school, for Kelso. But, so like I'm sorry, I have a bad migraine this morning. So do we have to be all in agreement if she plays sports, or if one parent is unagreeable, can the other one still do it on their own time? But then
I can also interlineate that they have joint decision making in terms of each parent can decide what the child does on their time.
That work for you?
Yeah.
Okay. Anything else?
No, I think it's good.
Okay, so Ms. Winkles will make those changes to the order. So I won't be signing the one that's here now. With those changes, are you okay to put approved?
Yeah, I just have one question. Our daughter's birthday's in not this Saturday, the following Saturday. In the paperwork, it says 11. Normally that'd be fine. It's just that we've already planned a birthday for her, but she would be there to his house by 2, which has been our normal time of dropping off.
Okay.
Just for that weekend.
Okay, I'm not going to put in an order one thing for one particular time. What I suggest that you do is talk to Ms. Winkles.
Okay.
And see if you can work something out. I always tell people put it in writing. So that way, if it ever comes back as an issue, you have it in writing. I would talk to Ms. Winkles in regard to that, okay?
Okay, sorry, I have one more question. Okay, when you say go into writing, do we just like put it in writing and have it served to him, or?
No, you can email, you can, whatever manner that you do, or you can type it up and you both sign it if you both agree. Those are all ways to document an agreement. Ms. Winkles, I don't know if you want to go ahead and add some language that they can make changes if they put it in writing and both sign.
Okay, sounds good. I'll do that.
All right, that way you're not, this is it and that's all, okay? All right, anything else? Okay. All right, so again, I won't be signing these documents. Ms. Winkles, if you could put approved, and then for her, or are you okay to have her put your name on it then?
Yeah.
Okay, just put her name on it, and then submit it to me for signature.
Okay, I'll get it to you today, Your Honor.
Anything further on this matter?
No, Your Honor, thank you.
All right, so with that, I will excuse the interpreter. Thank you.
That matter's ready.
All right, do we have, I'm not quite sure, is it Kel or Kele?
Keely.
Keely Bobst.
Keely.
Keely.
All right, we have Keely Bobs, and we have Ms. Winkles. This is in regard, I see that the service was on September 3, but I did not have a response. So, Ms. Winkles?
Yes, Your Honor. We served him both personally with the restraining order as well. And we also attempted to mail out the documents to his address. We also emailed, he did email me back communicating which address to send it to. We've received no actual response on the documents, so I ask that you, Your Honor, enter the orders as proposed.
All right, sir, anything you wanted to say at the moment?
Yeah, I was just kind of unaware I was supposed to respond to the restraining order. I thought, like, come here. I thought I was supposed to have court and talk about it here.
When we have a docket or a hearing like this, everything needs to be in writing. It needs to be filed with the court prior to the time of the hearing. It needs to be served on the other party. So when you didn't do that, I didn't have anything to review or read or consider in the order. So it was my intent to sign off on the orders that have been presented. Are you objecting to the restraining order?
Yes.
So are you going to be retaining an attorney, or are you going to be doing this on your own?
I believe on my own.
Okay. So you need to understand that I get that you're not an attorney, which makes it complicated. At the same time, you're held to the same standards of knowing the rules and what the requirements are. Okay, I cannot give you legal advice. There is Calico Legal Aid. There is and they come on Mondays from, I think, noon to 2 to talk to people if you have questions. And Northwest Justice Project is another possibility for talking to somebody to see what you need to do. But at this time, you were served on the 3rd. And here we are already on the 24th, so 3 weeks ago, and there's nothing in writing.
Yeah, I understand.
Okay. So what I'm going to do is I am going to be signing off on the papers today. That will put the restraining order into effect. But, you know, like I said, you can always talk to any of those groups that I talked to you about to see if there's anything that you can do differently. Okay.
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 And do you have those orders in front of you, Your Honor?
I do.
Okay.
All right. I have signed off on those orders.
Thank you, Your Honor.
All right, so we have Joshua Baldwin, we have Amanda Holder, we have Keith Lawrence. So I know I had emailed yesterday because I hadn't seen an interim, and I believe Mr. Lawrence had responded that with things changing, that he hasn't been able to do that, which is understandable. So, Mr. Lawrence, can you give me an idea of where things are at this point?
Yes, Your Honor. I had met for the second time with Ms. Baldwin on Wednesday, September the 11th, to discuss some of her acknowledged mental health issues. And she had acknowledged that she's had prior sexual abuse in her background as well. And during that conversation, she indicated that she was going to go to Vancouver. There's a place called Rainier Springs down there where she was going to get intensive outpatient treatment. She was to receive therapy 3 days a week for 5 hours per day. Then on September the 19th, I received a telephone call from the law office of Mr. Baldwin indicating that Ms. Baldwin had been involuntarily held under the Mental Health Treatment Act at that program. And so I emailed Ms. Holder because I wasn't sure what program she was being held in at the time that I received the information that she was being held involuntarily. So I emailed Ms. Holder on the 20th to ask whether she knew where Stephanie was. On the 20th, later in the day, I received a telephone call from Stephanie, who indicated that she had just been released from the program and that it had all been a mistake, that she had apparently walked in the wrong set of doors. And instead of talking to her counselor about the intensive outpatient, she ended up in the involuntarily treatment program section of it. And they wouldn't believe her story, according to Stephanie. And so they held her. Then they apparently realized that they had made a mistake and released her on the 20th in the morning. So at this point, I have many emails from Stephanie listing contacts between her and Mr. Baldwin, Stephen Baldwin, and that she's been trying to rekindle her contact with her children, and that he is balking at this point. Mr. Baldwin has filed to temporarily have the kids remain with him and allow his parents to provide care while he's at work. His father is Vance Baldwin, who I know from my days in the Cowlitz County Juvenile Department. And just a brief overview of his prior record shows extensive criminal history. And so that's kind of where we are right now. To my knowledge, Stephanie is not getting any contact with her children. She has sent videotapes, and Mr. Baldwin has indicated that he didn't feel the tapes were appropriate. The tape that I saw did not seem to be inappropriate in any way. So that's pretty much where we are right now. What I need to do next is to contact Rainier Springs and speak to the treatment staff down there to find out exactly what happened, why she was ITA'd, and what is the plan for her therapy in the future. And so that we can try to decide whether or not she's a threat to the children. Right now, I don't see anything that indicates she's a threat, but that's kind of where we are right now, Your Honor.
Thank you. Mr. Baldwin?
The accurate, I think, recitation, Your Honor. The information we received on Thursday of last week, I believe it was Thursday, was that Miss Baldwin was taken into a facility because she went in the wrong door. The kids were with an aunt. Our information was in the declaration by our client that we submitted Friday for the emergency order to take us into till today, was that my client was informed that she had been there for a day or two before he knew. That Friday, at the time we were initially drafting the pleading for an emergency order, the kids were with an aunt, or had been with an aunt until he obtained them, and that he found out later Friday morning. He was contacted by her that she was out and demanding the kids be returned. He expressed his concern, not knowing what's going on. My knowledge and information, but what he was led to believe, obviously in front of other people, is a person doesn't accidentally get held on a civil commitment. They say something that causes concern for either the risk they pose to themselves or to others, or lack an ability to care for their essential needs. We just didn't have any information. We did go forward with an emergency order that was signed by the court on Friday, taking us until today. So my client has the children. It was in the form of an emergency restraining order until we know more about what was going on with Miss Baldwin's situation and his concerns for the children's safety. He did allow videos. They were sending videos back and forth. The kids did video to mom. Mom did video to kids initially. And she did a visual symbol or sign that was viewed by him to be offensive. It's a sexually explicit hand gesture that I think she indicated she intended to do hang loose, or like this kind of gesture. What she didn't said was a different finger configuration that was viewed by him to be inappropriate, not knowing again what her situation is. We had no idea she was in outpatient treatment. We had no idea she was dealing with these mental health concerns. All we found out is she was being held in the hospital, and though she's maintained in Family Wizard communications to our clients since our filing that it was a simple situation where she was taken back to talk to them. She talked to them thinking she was going to be going to a group treatment. And based on what she said, they kept her in the hospital or in that facility for concerns for her safety, raised some very serious concerning flags. We did include that at least with that temporary order, that his parents are able to be used, mostly, Your Honor, because the suddenness of it, he didn't have other alternatives for care during the day while he's at work. This was not a planned out thing, so it was unfortunately having to be dealt with somewhat on the fly. But there is a temporary order that runs through today, and if there is more information, I'd ask the court maintain that order and set phone or video for mom at this point, visitation until we have more of that information.
Ms. Holder?
Yes, Your Honor, just to clear up the hand gesture, first of all, it was this, which is an I love you symbol in sign language in ASL. So I'm not sure where the confusion came for that. My client has been released. She is she's doing well. What is troubling about this, besides the fact that there was an involuntary hold, is that the ex parte order, the emergency order, created a loophole where people who are not normally allowed around the children and there are limitations placed on them are allowed to give those children childcare. Now, I understand that was for a short period of time, but that cannot keep going. As Mr. Lawrence stated, there are some serious concerns about a criminal background, and that is why we really pressed for, in a temporary order, making sure that Mr. Baldwin was not to take the children around his parents, is because of those felony convictions and the issues there. The second issue, as Mr. Lawrence stated in his recitation of facts, is that my client is not able to have steady, consistent contact with the children. She's basically been put through a stressful situation. She gets out of it. And then one of the reasons she sought mental health treatment is because of the divorce and because of the custody arrangements and the stressors there. And now she's not allowed to see the kids or talk to the children. And father is saying, oh, I'm allowing these video calls to happen, but if she does anything that I slightly perceive as offensive, I'm going to cut the call short. So while I do agree out of an abundance of caution, I don't disagree with the ex parte order, but we need to come up with something that's going to be sustainable and work in the long term. I would ask Mr. Lawrence just how long he thinks he can get an interim report out so that we can figure out where these children need to be during the pendency of this litigation up until we can get a full GAL report. I don't think staying with mom or dad is necessarily a problem so long as the children are safe. I believe they are safe with my client. The facility saw fit to release her. And so I would ask that the children go back to being with Miss Baldwin until we can get some type of interim order, or sorry, interim report from Mr. Lawrence.
Mr. Baldwin?
Yes, Your Honor. As far as the gesture, I believe my staff is looking now. There was back and forth about maybe she planned it was inadvertent, but instead of doing this, she did this, which is a different gesture. And then there was back and forth between them saying it was an accident. As far as the parents, it is in his motion for immediate restraint. Nothing was being hidden. The current temporary order prevents my parents from having contact with the children. You know, they've been a part of their lives because they have felony conviction history. But under this emergent situation, I need their help. So we weren't trying to hide anything. This is not an end around or an attempt to circumvent the ruling the court made on the temporary order. There's a contempt that's currently pending, I believe for October 15th, that has been served on Miss Baldwin, where she was out of town and didn't provide notice to my client for right of refusal. And it includes another incident where she violated the order. More, I think, informational than anything else. The request initially was to prevent my client's parents, particular parents, the ones who were part of the criminal case that Miss Baldwin was dealing with in Oregon, from having contact with the children. Language was crafted specifically including them, and there was some dispute at the presentation of the order because Your Honor, I think, said family in general as opposed to them specifically, and we used them specifically and included anybody with felony convictions or known to have felony convictions. The other set of my client's parents, his parents are separated and remarried, so there's a mom and stepdad, dad and stepmom, were contacted by the respondent and were given time with the children, even though they're known to have felony convictions by her. So we argued at the time that that was lip service to sort of keep this family away because the criminal charge that was pending, it's neither here nor there directly. It just, I think for informational sake, I want to be clear that we weren't trying to hide anything from the court. We weren't trying to pull the wool over everyone's eyes. He had no notice that this was going to happen, had no idea how long it was going to be this situation. So he's asking the court to maintain the emergency order that was entered on Friday, at least another week. And this is the still of the video, Your Honor. I'm going to turn off my blur if I can.
I thought.
Yeah, perfect. So that's something that he took as being concerning, or it's an offensive sign or visual representation from what he understands it as, and was, again, concerned because we don't know the nature of the mental health counseling, the diagnostic impression, or anything else. So that's where I think we are, Your Honor. But I'd ask the children remain with my client. Your Honor, set phone calls or video visits and try and set a shorter review as possible. As I said, I know we are already on for the 15th to deal with that contempt issue as well.
Ms. Baldwin, my one question, and maybe you said this and I wasn't real sure, is there anyone else for care of these kids? That's my concern while they're with dad.
My client and I haven't had a chance to talk about that, Your Honor. He is on. I can let him answer whether he has any other family. I know that their aunt had been watching them for mom. I don't know if she's available during his workday to watch the children, if Your Honor wants to remove them from being available, but he is present and can answer that question.
Stephen Baldwin.
Yes, ma'am. So currently my living situation has kind of pushed me to lean against my parents for this. I don't have an alternate that I've arranged. If given some time, I can find an alternate. But, you know, without saying too much, I feel like these limitations were put against my parents as...
Okay, I don't want to hear that part.
Okay. So I don't currently have an alternate childcare set up, but if given time, I can arrange those.
All right, thank you. Ms. Holder?
I'm sorry, Your Honor, I have some lawn crews right outside. Your Honor, I'm not sure what the right solution here is. If with the questions of my client's mental health and
let me say this. My intent is to leave the children with the father at this time. I don't know of anyone who is accidentally ITA'd. So
can I say something? Can I say something?
No.
Oh God.
I don't know of anyone accidentally ITA'd, and there's going to have to be a real showing of something that happened that somebody at that agency messed up. But at this point, I am going with the idea that she was ITA'd. There's serious questions in regard to mental health, And so at this time, the children are going to stay with the father. However, I do not want them with the grandparents. That was all litigated. I get that it may not be convenient for something else. If he can work with the aunt, great. But you know, I get that this was on short time. But at this point, the court has significant concerns. So let me ask Mr. Lawrence. Mr. Lawrence, you seem to have some background and information. What is your thought for just the rest of this week with the grandparents?
Well, it's risky, Your Honor. However, I'm not aware that there's been any abuse towards the children by them. I'm not aware of any neglect issues, but I think that Mr. Baldwin really needs to resolve this by the end of this week.
Your Honor, one question, I guess one thing that may help with daytime, the kids they're not enrolled in school. Mom had been homeschooling. My client has some concerns now that they're with him, that they may not have been making any progress in school, at least so far this year. Enrolling them in school would have them somewhere during the day they're going to be getting education, which they should be getting, and would manage the daytime period that care is primarily needed. And that's something my client is indicating, I think, in his other declarations when he initially filed pro se, he was wanting to do. So that's one possibility. I just wanted to make sure I threw that out there.
And I would object to that, just because if it's not going to be a stable situation, we're risking putting children into school and then taking them out back to back.
Yeah. So I don't want to see changes, any other changes for the children than are necessary at this point. When we get to the interim report from Mr. Lawrence, we can take a look at things. But right now, they'll stay with the father. I'll go ahead and allow them to stay with the paternal grandparents through the end of this week. After this, there needs to be another alternative that's acceptable to both parties. I'm okay if you can work something out with the aunt or some other family member that's acceptable. But I'm not going to have them go into school right now. That'd be too much change for the children. Meanwhile, in regard to the mother's visits, it will be video visits. It will be 3 times a week. And it will be from 6 to, remind me the ages. I don't have their.
Young, I think 4 and 2.
Okay.
4 and 7. 4 and 7, Your Honor.
Okay, that's right. Okay. So they're pretty young. So I'm just going to make it for an hour, and she'll be lucky with it, getting attention for an hour. And that's not to say anything against the mother. That's just the age of the children. So we'll try for an hour 3 times a week, Monday, Wednesday, Friday, 6 to 7. And then we'll come back on October 15. Hopefully that will be enough time to look at everything and have something more solid as to what's going to happen from there.
Thank you, Your Honor.
Thank you, Judge. So all the remaining issues will be over the 15th as well?
Correct.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
We have Mr. Anagnostou, we have Ms. Gilmore. All right. So I received late yesterday objections. Ms. Gilmore, did you receive that?
I received that on Friday late in the day, and then I was out yesterday.
So I went through the objections, and this has been one of those that is complicated. It reminds me of when there's child support due, and when the motion gets filed, the child support gets caught up. To me, it's similar in that nature. On one hand, meaning that the sale of the house at the time, the court didn't see any showing that it was had been sold, is my recollection. but the objections seem to be primarily reconsideration requests rather than objections to the order. The only one that I saw had to do with, let me try to get it back here. Objection to paragraph 5. The order does not set forth the basis for contempt. Let me look here.
And that's page 2,
Right.
line 5. I typically just do as described in the motion. I'll defer to the court if you want me to make specific findings. I'm happy to add that in.
I think it would be more appropriate to do specific findings rather than defer back to a motion for contempt.
Okay, if you'd like to give that to me, I can add that in, or if you want to write it in.
Go ahead and just redo it. And then as to the other objections to paragraph 6 and 11, as I said, I reviewed those. They look more for reconsideration than, or they look like reconsideration rather than objections to the order. So I won't be ruling on those.
Your Honor, can I be heard?
Go ahead. Well, I mean, I've seen the objections.
Right.
I usually just go through them
And part of the issue is you have to go back to the motion. And in the motion, there were all sorts of allegations that are not applicable to my client being found in contempt. Like providing updates and refusing to put the home on the market. That's not true. The home was on the market. Anyway, that's in her motion. But in her motion, with regards to fees, because the fees have to be, there has to be a showing of what the fees were under the Lodestar analysis. She asked for $3,000 fees, but somehow the court ordered $5,000 in fees, and I'm, so I just wanted to point that out to the court that, part of the other objections, my objection to paragraph 3 was that there was no showing what the fees were under Lodestar, and somehow they got almost double. I mean, they went from 3 to 5 for no apparent reason.
Then that was my error, Ms. Gilmore.
So if the court recalls, we originally asked for 3, and then in our reply, we asked for 5 because he refused to accept service. We had to do a motion to for service by mail. I had to appear at several hearings to get that done. So that was the basis, I believe, of the court. And so we asked for 5 in our reply. We asked for 3 under the underlying motion.
No showing of any of that.
Okay. So in regard to that, again, the court sees that as a motion for reconsideration. I'll leave it to that. I'm not going to make any further changes other than to paragraph 5. I do agree that there needs to be some specifics.
Can the court give me some direction on what you'd like? Because I just don't want to go back before the court. Just willful intentional violation of court order, just some standard language, or?
Correct.
Okay. Understood.
Okay. All right. So with that change, Mr. Anagnostou, I understand it may not be what you want. Do you approve the assume that it reflects my order?
If Miss lose my train of thought. If Miss Gilmore is going to redraft the order, she needs to serve that on me and give me an opportunity to object to now what she's presenting to the court.
Okay. All right. That's fine. I guess what I'm asking is when she does, if you can just let me know
Sure.
one way or the other, so we don't have to put it on another docket, and I'd rather just deal with it. Okay.
Okay.
All right. All right. That's it for today. 08 Gavino v. Cook.
Ready?
Turnbull has with us online.
I do see Ms. Turnbull online. Ms. Baldwin is present in the courtroom. Mr. Sandy is present in the courtroom. There are 2 matters on. One is a presentation of order. I did not see any objections to the order, so I do need to clarify because there are 2 orders that were presented. Want to make sure we're talking about both.
I think over the course of the past couple of months, there's been about 4 different orders. I think we've agreed. I think we're up to date with that. I think we've agreed to all of those.
So these are the contempt order and the order on hearing of July 23rd. I think the only thing that I changed was we had paid those fees in between us sending you and us sending a copy to the court. So I just indicated that the fees have been paid already.
So we're good with that.
Okay, with both of them?
I believe so, yes.
Okay.
We had an argument on that a couple of weeks ago. Council didn't make those changes. I did review it. Mr. Gavino did pay the $500. I think we're squared away on that. So
Can you go ahead and just sign those
Sure.
since we're actually here in the, both in the court?
This is so weird.
We were also on to review.
The other review, guideline review. Ms. Turnbull?
Yes, Your Honor. I'm assuming you've read my report.
Yes.
Yes, and I did have the opportunity to speak with Nova Grant, who is Jameson's counselor. Would you like me to give you an update regarding that as well orally?
Yes.
Okay, so essentially my assessment through the chart notes was in alignment with what her oral recommendation would be, that she felt that Mr. Gavino's home provided more stability for the children and a little bit less chaos. That Ms. Cook certainly loves the children, but her life is just a little bit more chaotic right now, and that the children are doing better in Mr. Gavino's care because of the stability that he can offer. And so that would be her recommendation as well. And so that is my recommendation. I think that in light of how well Kyson is doing in school right now, in light of Ms. Rosen needing to have a little bit more time to assess and make her recommendations, and in light of needing to protect Kyson, given how vulnerable he is right now, that we hold the status quo.
Right. Counsel?
Which, who do you want to hear from first, Judge?
I think Ms. Baldwin at this point.
Yeah.
So just for the record, I represent the father and Mr. Gavino. And at this point, with the court, the current status quo is essentially the children are with my client during every weekday. They're with the mother during the weekends. And we are asking the courts to largely adopt that with a couple changes with the eye to the reality of the upcoming seasons. There are a number of concerns. Those concerns have been sort of present throughout this case. But I think that you see them really sort of bubbling to the forefront and finally getting to a point where we have professionals weighing in. And we now have in Jameson's counseling records, we have this evidence of sort of dad and Jameson and this very positive dynamic, very healthy dynamic where, dad's kind of like, hey, I'm here for you, kiddo, and child is reciprocating, and any sort of treatment that's been recommended, my client does it. Any sort of change that's been recommended, my client does it. If the counselor says, hey, you should do this in your home, my client does it. And that's contrasted when you see mother in Jameson's appointments. And it's this very tense, where mother, the notes are she's visibly upset, that she's stating that she's frustrated. This is the child's appointment. It's not her appointment, it's the child's appointment. And she talks about how, she's upset with child and is visibly upset. And ultimately, child talks about in dad's session how he's safe in dad's home to talk about his feelings and how he's frustrated about in mother's home, dad being talked poorly about. I think that just kind of really drives home the contrast in these two households and what these households are willing to do for these children. And where we are, the respondent mother is just unstable. We've had a whole bunch of different moves, different homes, different people coming in and out of her life. We know that she's currently pregnant. In the context of a case where we have a child with some really high needs, and it's kind of at a crisis point in his life, throwing all of those things together, mom's whole household is just very chaotic and isn't able to put either of these children's needs first right now. My client's home is stable. They're both, my client does what the children need and puts the kids first. And you see that in the reports. Thankfully, we do have, Jameson is going to treatment with Ms. Nova Grant at CMAR. We do have Kyson with Ms. Rosen who'll be working with him. Ms. Rosen does report. I'll build a report very well. She needs additional time. Just hasn't gotten to the point where a child can really pinpoint some of the perhaps sparking incidences that have gotten us to the place where we are with Kyson. But the concern for Kyson is sky high. And Ms. Rosen makes no bones about that the concerns for Kyson are like 9 out of 10. Like, this is a child who is in crisis. This is a child who needs absolutely to be cared for. This is a child that is absolutely critically vulnerable. And if we do not act, this is a child that will suffer. And so it's important that we keep that at the forefront. My recommendation would be that we adopt Ms. Rosen's recommendations, and those are the same recommendations that are outlined by the guardian ad litem at the last page of her report. I think that those are reasonable. And I think that we should come back to review in sort of mid to late January. That would give Ms. Rosen essentially 3 to 4 months to actually work with Kyson, issue a report or information maybe at the beginning of January, and then give everybody time to sort of look at it and then come back mid to late January. So that was sort of my thinking on that time frame. Pending that, what we'd ask the court to do is that maintain the same structure that we have now. Except I would ask that my client have 1 weekend a month. It's important that my client have time for memory building and positive things, and not just sort of the work a day, get to school, get your lunch, get home, do the thing. So I do think it's important to have 1 weekend a month. And then the court should also adopt the holiday schedule that both parties, essentially the same holiday schedule that they've always had, because we do have Thanksgiving and the Christmas holidays coming up. And I think that that's appropriate to make sure that we maintain some holiday consistency. But we should maintain the separation between Landon and Kyson. But we should continue to follow all the recommendations of both Kyson's providers as well as Jameson's providers, as well as the recommendations of their school, to make sure that everybody's being compliant with the recommendations that their school has for them, so that everybody is sort of in step together and sort of keeping these children's needs and vulnerabilities critically at the forefront.
Thank you. Counsel?
And thank you, Your Honor, where I do represent Madison Cook in this matter, and we're largely in the same spot we've been in the last couple of months. We have all conference with Ms. Rosen last week. I think that was very productive. One thing that did not occur from that is pinpointing exactly where this source of issue comes from with Kyson. Ms. Rosen, again, I think was asked directly a time or two, or at least 3, in which she thought or suspected could be the root of that. She had no indication. She made no findings on that. Continues to work through that process. Again, she's met with Kyson only 3 times. They have built up a rapport. I think that's positive. I think a lot of the insight from Ms. Rosen from that meeting, again, was well received, at least on our end. And I think it's beneficial moving forward. Again, and you've heard me say this countless times throughout the course of the summer, assuming that one party or the other is somehow victimizing this child is extremely misplaced at this point. We have the same information that we largely had a couple of months ago. We have Ms. Rosen, who again states that very unabashedly that child had access to a tablet at dad's house that was largely unfettered access. This child could do whatever he wanted to do. Dad eventually stopped that access and put some safeguards in place. We're now understand that Mr. Gavino has taken the tablets, which I think is a positive step, disallowing access from the child. We have the child again with these kids from Butler Acres who is going to the sleepovers. Electronic devices are readily accessible to these kids. We have no information of what's been viewed at that point. We have no information from or any kind of definite finger pointing that the uncle of the child is doing anything inappropriate with him. We're largely in the same spot with that. What we have now is, again, I think admittedly, 2 kids who desperately miss their mom, 2 kids who don't understand. Again, that's evidence from the information from the counselor, in which, to my client's credit, she's not telling the kids, she's not engaging them in this process, and they have questions. They're at that age where they're very inquisitive. They're at that age where they miss mom. They miss the time that they have with the extended family. It's been decreased significantly over the past couple of weeks. Is that best for the kids? So we're punishing the kids essentially based on an assumption and an allegation that doesn't have a real stronghold at this point. I would argue that that's not appropriate. I would argue these kids should have equal access with mom the same way that they've had over the past 3.5 years since these parties separated and moved on. It's what they're used to. It's what they're accustomed to. I'm somewhat off-put by the suggestion of the GAL and council that my client is living some kind of a chaotic life. That's news to me. That's never been presented to this court in all of the hearings we've had previously. And also the suggestion that Mr. provides the more stable home, and when the evidence in the record does not indicate that, somehow saying, well, he's following the court orders. Well, so is my client. My client has gone so far to protect these kids, to eliminate them from the assumption and the allegation that's continually lodged by dad, that she's moved from her residence to be with her grandparents, to eliminate any suspicion, eliminate any potential risk, and she's done that. Again, her half-brother is out of the picture. If he was doing anything to these kids, and again, Ms. Rosen doesn't believe, or at least that was my understanding, that anything sexual in nature has happened outside of this repeated access to pornography. Everybody agrees that's inappropriate. So again, to assume that this individual is the source of these kids' contacts and exposure isn't based in fact, it's based on suspicion. And we all have suspicions in this case. My client has moved. Ms. Turnbull states that's a positive place, that there's no inappropriateness with this location, that it's well suited for these kids. Kids are in the same school district. Kids miss mom, mom misses the kids, and they miss the function and day-to-day activity that they've had for the past 3.5 years and have enjoyed under that existing parenting plan. That needs to remain. I think the safeguards in place, and I think from my recollection, I asked Ms. Rosen specifically, I believe council may have had a follow-up, if not Ms. Turnbull did, about suggestions for the plan moving forward. She didn't have that information at this point. I didn't have any information as to what was appropriate given the circumstances. What I can remind the court is that the temporary arrangement was meant to be exactly that, and that was temporary, pending more information. We simply don't have it. The only thing that's changed in Ms. Turnbull's recommendation is the chart notes from Nora Grant at CMAR. And again, the one thing that stands out is Jameson is still having defiant behavior towards mom, to the point that grandma has noticed and even said something to him about the way he treats his mother. We don't know what the source of that is. We don't know if that's from Jameson. We don't know if that's from Mr. Gabino. And again, Mr. Gabino, as you are well aware, has been directly involved in all aspects of these kids' counseling and has kind of made it his obsession since this matter commenced about 2 years ago. So that's where we're at with that. So if we look at this at face value, there's more questions than answers. Again, that's been a resounding theme throughout this case over the past 5 or 6 months. We're still in that same spot. What we can hold on to and what we know is, again, these kids miss mom. Mom has done everything and bent over backwards to follow the orders of this court, going so far as to taking the kids completely out of the purview and eliminating any contact they have with the uncle. She's gone so far as to relocate so she can do that. And of course, that's going to come with transition. And if that's considered chaos, then there's chaos that resonates through a lot of people's lives in this courtroom, because that's not uncommon. She's doing everything that she can to keep these kids safe. We would ask that we revert back, again, understanding that this was only designed to be temporary until we could get information from Ms. Rosen. Revert back to the way it's been for the past 3.5 years. And we're always, the courthouse doors are always open. Once we get information from Ms. Rosen, if any at all, that's going to be useful in determining what's happened to at least Kyson. Both parties know how to come back and have that matter reviewed. But just to assume that something's happening only to be wrong in 3 or 4 months and then go to a different plan at that time, I think would be detrimental to these kids. Certainly would not promote their well-being and their emotional health and the relationship with both parents. That's our request. I think that's based on, again, logic and reason. And lastly, as it pertains to my clients, this notion that she's been is somewhat frustrated by. She has, and rightfully so. This has been 2 years where she has been under the microscope and all sorts of allegations lodged to her, and very few, if any, have ever been found to have any credit at all. She is tired. She has made significant adjustments, again, to appease the GAO, to appease the interests of this court, and most notably to preserve the well-being and best interests of her children. Again, I think she should be lauded for that. So that's where we're at. We would like this to go back to the way it was and revert back to the original parenting plan. Again, I do think we need to err on the side of caution. We have no issues with Ms. Rosen's recommendations. I think those make good sense. I would sentiment thoughts of the GAO and Ms. Baldwin as it pertains to that. We would be willing to adopt those. Again, it's maintaining the safety of these children in our proposal, I believe, does that.
Briefly in response.
Go ahead.
Well, mother says, well, I've done everything I was supposed to do. But even in this case, the court said when we came before the court for contempt, the court said, hey, I do have concerns though, because you haven't shown that you've done these appointments. And we're still in a position where she has not filed when she did these appointments and what those appointments were for, whether they were just intakes and she never did the treatment that was actually ordered by the court. So again, concerns there that she isn't actually doing the things she needs to do. We are in a different position. We have information from Ms. Rosen, we have information from Ms. Grant, and so we do have different information. We also have the reality of what happens when these children are residing under the current situation, living primarily with that. And the reality is that since school has started, that Kyson is doing well. So we have sort of an objective measure of a child who is now moving into or towards stability. And we also have Ms. Rosen's statements that this is not borderline. This is 9 out of 10. The concern is as basically as high as you can get it for the needs of this child. And it's critical that we pay attention to it. In this case, we do have instability of Mrs. She's living in a home with her boyfriend, then in a trailer, now in her grandparents' home, all within a pretty quick amount of time, and some very significant concerns about sort of the household and how the interactions.
Just real quick, counsel, just want to object. I don't think there was any information that she's living with her boyfriend currently. She's living.
No, not currently. She was with a boyfriend, then in a trailer, and then with the grandparents. And that was all within a fairly quick amount of time. And when you look at the children themselves and how they're interacting with each parent in each home, there's just, at this point, we do have evidence, and that evidence does lead to concerns. These are children who need stability to heal, and need stability so that they can move forward in treatment for both of them. So I would ask the court adopt the recommendations of Ms. Rosen, which are echoed by the guardian ad litem in this case, and as well as my slight tweaks to ensure that we take care of holidays. Again, my client in no way is trying to box out the mother, and you see that even in the GAL report, as well as in, I believe, statements of Ms. Rosen and the Ms. Grant. My client's kind of saying, hey, I'm sure she loves these kids, she's doing the best she can, but she's not in a position right now to be the primary parent or to be a 50-50 parent. It's just not what's going to work for these kids right now.
Ms. Turnbull, anything that you wanted to add?
Well, a few thoughts. One is Miss Grant, who has been working with this family for at least the beginning of this year, if not over a year. My chart notes went back to January. She reported she'd been seeing them since about October of last year. She's the one who used the term to me, chaos around Ms. Cook. And so, and she's had the experience working with Jameson and the family to observe that. Ms. Cook did bring up to me over the weekend that she has had more visits with Core Health than I reported. So I'd like to acknowledge that I reported on everything, all of the records that were forwarded to me by medical records. She reports and that there are more that I didn't see. That may be true, but what I can say is that observationally in the home, the children are responding better with more structure in Dad's home. And that's not to say that that can't happen in Mom's home. It's just not happening currently. And I think Mom can get there with some work, but currently at this time, it's happening in Dad's home. And I think for the children's best interest, that's where they need to be. And I think that that's evidenced by what you're seeing in the chart notes. I think that's evidenced by how you're seeing Kyson respond at school this year. So hence my recommendations.
All right, thank you. So this is a very difficult case. It's difficult in the sense of the issues that we are dealing with. And I want to be careful and mindful of the uncle, and we don't know. And the court understands that. At the same time, there is significant concerns, or at least concerns. So when looking at this, and I've said this many times, the court looks at the recommendations of a guardian ad litem as just that, recommendations. At the same time, the court looks at the big picture of everything and what to consider. And the court, again, looking at this case, looking at everything that's been brought up, that the court has the same concerns and issues that have been brought up by Ms. Turnbull. And we have to look to the experts. It just requires that in this matter, which many times it does, but more so in this matter. So with that, the court is following the recommendations of Ms. Rosen and is adopting the recommendations of the guardian ad litem. At this time, the court finds that most appropriate for the children, where they will do best at this time. Whether that remains the case, time will tell. But at this point, the best interest of the children is to remain where they are.
I made a request for essentially 1 weekend a month. Would be my client would have 1 weekend since mom has all the rest of the weekends, and then also to adopt some sort of holiday schedule. Did you have a rule on those?
Anything you wanted to add?
Well, again, the timing is always difficult when you have the GAL review. So I've emailed and my client's in ready communication with me. We do correspond quite a bit. It's largely email and we can. I'll have her in and talk to her as we would normally see. I would like to get some input on what she would like for that schedule if we're going to change things over the next foreseeable future. I can't say with any conviction one way or the other how she feels about 1 weekend a month to dad. If we do give 1 weekend a month to dad, I think I know her well enough to think she's going to want to get that someplace else. Maybe 2 overnights on a Wednesday, Thursday, or something along those lines. But again, I don't have direct authority from her.
You want to address it on presentation?
Right, that'd be
Mr. Sandy, I
wise
see if
to
we can
do.
work it out.
That's fine. I would say it's very standard for me to, if somebody has every weekend, because I see it with, especially with some of the schedules, work schedules, that one does go to the other. I understand the mom wanting makeup. So I would just attach a Thursday to a weekend that she has the children, and that essentially makes it up. So
A long weekend.
mhm.
Okay.
And then this just a standard holiday schedule.
I'll propose now with that kind of structure, I'll propose a parenting plan. I'm sure council will do the same. We'll communicate, see if we can work it out. If not, present those to you on presentation. We have 3 weeks for that presentation to the 15th, just to give us a little bit more time to get things back and forth. That be 15th, I believe. I apologize for that. That is not a phone. It's a medical device.
Yeah, 15.
No worries. I think you identified that at one time, so.
Oh, I'm in trial that day.
Then I'd rather do either the 8th. Mind doing the 8th?
I'm good with the 8th.
Okay, let's do the 8th then.
Okay.
That covers it. Any loose ends?
No. Anything extra, just have place. Yeah.
We have Renee. Is it Frankel? Am I saying that correctly? All right. All right, and Ms. Gilmore, I've read the motion. Ms. Fragel, anything you wanted to add?
Yes, Your Honor. I did not have time to respond to their response because I received it Thursday. So I would like to point out that RCW 4.72.080 does give you the authority by saying when after the entry of a judgment, either party fails to fulfill the terms and conditions on which the consent judgment was entered. I have lined out in all of my paperwork how we did not fulfill the terms and conditions. And that allows the court to negate the 1-year rule.
Anything else?
I don't believe so, Your Honor.
All right, Ms. Gilmore?
Your Honor, I was just pulling up the proof of service. I think my staff sent that over 2 weeks ago on what looks like September 9th. So I'm surprised by her just receiving it. If the court wants to entertain a set over, that's fine.
There was
but
one
I
that you
don't.
sent that never arrived as well.
Ms. Fragel, please don't talk over her.
Oh, I'm sorry. I apologize.
Gilmore, what were you
So
saying?
I'm fine with a set over if she would like to provide additional response. I don't think it's necessary at this point. My memorandum's pretty clear. I don't think CR 60 or 59 applies in a case where an Oregon order was entered over 16 years ago. I can cite some of the case law, but I think that again, it's straightforward. So I'll defer to the court if you have any questions for me.
Ms. Fragel, I want to make sure you have an opportunity to be heard. Do you want to set it over to respond to their?
No, Your Honor, I responded with the RCW. Do I need to put that in writing?
Yeah, that's fine. You're fine. Ms. Gilmore?
Sorry, did you need something else from me?
Go ahead. Anything you wanted to add?
No, Your Honor.
Okay. All right. Any argument, Ms. Gilmore?
I'm happy to present argument, Your Honor. I cited it. Did you see my memorandum?
I did. I apologize. I wanted to make sure everyone knew what I was talking about. We can go ahead. I didn't know if there was anything more you wanted to add. Sounds like you don't, but just want to make sure.
Not necessarily. Again, I think that she's barred under CR 61 1 through 3, given there's a clear 1-year timeline. The others from 4 to 11 say reasonable timeline. I would say under any definition of reasonableness, trying to vacate an Oregon order that's 16 years old isn't reasonable. Again, I provide a case law that reconciliation doesn't invalidate decrees of legal separation. That's still good case law. A change to the parties' financial situations will not justify application of CR 6011. So frankly, I just don't think that there's any basis for us to be here today. This is the, I want to say, 4th or 5th motion that we've been before the court since the spring of this year. So I am asking the court to enter an order prohibiting abusive use of litigation in this case.
Ms. Fragel?
Yes, she actually wrote out
You
what my
talk about
motions
this a
were.
bit. I can't quite hear you.
Okay, how's that?
Better.
Okay, so Ms. Gilmore pointed out my motions, and they all have basis in law. And when he was taking my things and breaking them and putting them outside, you entered leaving respondent's property alone, that he has not done. So I don't understand how I can be considered abusive litigation when he is not following court orders and I have to bring him back to make sure he does.
Anything else?
No, ma'am.
All right. So I did review the files and record, including the memorandum of law and familiar with the statute that was indicated. But based on that, the court does deny the motion to vacate the order. More specifically, the parties entered a general judgment of separation on June 18, 2008. Under CR 60, the motion is to be brought within a reasonable time and for certain basis under 60B 1 through 11, so 1 year after the judgment order or proceedings was entered or taken. We are way beyond that, and even if not, there is no showing of any of the identified sections as a basis to vacate. There is no showing under rule or case law to vacate the general judgment of separation, so the motion is denied. So with that, I don't have an order to sign in regard to the, I'm not going to order the litigation request at this time. May if it continues, but at this point, I'm not going to. But Ms. Gilmore, do you want to prepare an order, or Ms. Fragel, do you have an order? I didn't see one.
No, Your Honor, I did not turn one in. I've got it with me.
I'm happy to do an order if the court would like me to make findings. Alternatively, the court, I'm happy to also just do a bench order. The court doing a bench order saying it's just simply denied, whatever you prefer.
Okay. All right, I'll just do a bench order, Ms. Fragel, which is something I just write up. So it's taken care of. Okay.
Okay.
All right.
And then can we move on to the next part?
The next part being, what are you talking about?
The response to the 7-9 declarations. And specifically the fact that I have a notice of entry of judgment, including a judgment lien for him to pay child support. If we are going by the 2008 order,
Ms. Fragel,
I need to
that was
turn
Ms.
this in.
Fragel, stop. That's not on today's docket. It was not.
It is.
At all.
I can show you right here. It is on the docket, right there.
Okay, well, it's not showing on my docket, so I did not prepare for it.
Well,
I think what's
Go ahead.
I think what's happening is the last time we were before the court reserved the issue of back child support for trial. I believe what she's trying to do is reconsider that ruling or provide more information on it.
Okay. Well, it's not before me. Ms. Fragel, it's not before me. I won't be ruling on it. I've already.
Okay, well, as far as I understand, you don't need to because I already have the judgment and the order and the lien paperwork. I
That's
just
up
turned
to you
that
to
in.
do it, but I'm not making any further rulings on it.
Okay, that's fine. It's already been ruled on, Your Honor.
All right, that concludes that matter. We have Ms. Turnbull, we have Ms. Baldwin, we have Lacey Klopp here in the courtroom.
So there are a few things, but in this case, I'm actually going to ask the court continue this matter 2 weeks. Ms. Klopp didn't file her responsive materials until I believe late Thursday of this last week, and then the guardian ad litem filed materials yesterday. But given that, those are both very late filings, I think it's appropriate that we continue it so that my client can receive those, review them, respond if necessary. And I think if a response is necessary, that's why I'm asking for 2 weeks, just so that there's a response that actually makes it to the court file, and then we can have an orderly hearing. The materials that Ms. Klopp filed are pretty extensive and fairly large, and so I do think it's appropriate that my client have an opportunity to review them and respond if necessary.
There must be something I didn't see.
And it might not have made it to the court file based on when she filed.
When did you file it, Ms. Klopp?
Between that and the restraining order, there's been a lot that I had to file. It might have been Wednesday or Thursday, but I did send bench copies, so they were going to have them on your desk.
Okay, so the request is to continue it. Any objections to that?
I just don't think it's necessary because it's been continued nonstop since May 14th. I just would like, to finally be heard and move on.
Part of the problem is I haven't read everything. So the other thing that I wanted to make sure is clear to everyone is I had talked about a motion needing to be filed to adopt the recommendations of a guardian ad litem report or modify a temporary order or anything like that. But there's no note for docket, so it's not actually noted up. And I recognize you're not an attorney, but it gets it on, so I know that's what's going to be done. Because with the many cases that I deal with, I need to know what am I actually doing that day.
Okay.
So that needs to be done as well. So I would not have considered that motion or that request today anyhow.
Okay, I just had figured the clerks would have said, I don't know, just kind of.
I so you will need to do the note, make sure Ms. Baldwin and Ms. Turnbull get a copy of that.
So do I just go to the clerk's office and say that I need like a docket notice for the motion?
Correct.
Okay.
That should be, I guess I don't want to speak for the clerk's office. Can
I'll
she
just talk to them
go get it?
afterwards
Yeah,
and
talk
see.
to them.
Okay, thank you.
All right. So if that's the idea, I'd like to set it over to October 15th so everybody has time. That work for you?
That's fine.
Your Honor, that's the day I'm in
Oh,
trial.
that's right.
I can
Okay.
either do the 22nd is fine.
Okay. So October.
Maybe the 22nd.
Okay. Does October 22nd work for you?
Because there's really no other.
Okay. All right. So let's go to October 22nd.
We did have a presentation on, there weren't any objections to that, so I don't mind doing it today. I'd rather get that entered just because I've worried that I'll get lost again. Okay.
Let me look at that.
That was just on the order to compel.
The protective order also getting that thing being moved out.
What's that?
The motion for the protective order for discovery.
Okay, so let's talk about the order first, compelling answers, and I reviewed it. It appears to be reflect what I had ordered. I didn't see any objections from you, and the court rules require you to put it in writing and file your objections. Did you? Okay. All right. I understand you may not approve of what's in here, but do you approve as to it reflects my?
Yeah.
Okay. Baldwin, I've signed on that order.
Right.
And then if you want to address the, all right, so I reviewed the motion for protective order that was filed quite some time ago. May 28th, 2024. Was there anything that you wanted to add in regard to that?
It was just had been lost between transitioning between Scott and then Miss Winkles and then me being by myself. So that's why it was taken so long between. I didn't realize that a doc notice was never done. But for the protective order, I know that she said the subpoena had already been issued, but it was also objected to. And from my understanding, there's like certain things that need to be done for an objected subpoena instead of just sending it out. And then there's also the number 4 request for production is in the protective order because it's asking for all text messages that I've had since 2022 until present. And I just think that's like overly burden and it would affect a lot of people's privacy that they have with me, including my work employees. I have 2 jobs. I have clients that I talk to. I just think that it's irrelevant to this case. It's overly broad.
All right, Ms. Baldwin.
First of all, the protective order was regarding the subpoena for the phone records specifically. So she can't now say, ooh, let me lump in other things I want to protect. Now, she can't do that. It's only regarding the subpoena. We filed a copy of the subpoena for you in with our response. Number 1, this is moot. That they essentially abandoned their request. For them to obtain a protective order, they have to actually file it and bring it before the court. It's not a way of just filing it and then just thinking that that acts as sort of a barrier. You have to actually bring your motion. You can't just file an objection. That's not sufficient to protect, and the rules in that are very clear. Number 2, when you look as far as it being overly broad, it was regarding 2 phone numbers. And we ultimately only ended up requesting, after I spoke with opposing counsel, I agreed to limit it from January of this year till when we sent the subpoena. So 2024 for 2 phone numbers for this period of time. So essentially it ended up being 5-6 months worth of time. So that's very direct, it's very limited. It's limited in scope, it's limited in time. There's no burden on her whatsoever, so there's no cost to her. These are phone numbers associated with people that we have concerns that would relate to 191 factors. And essentially what this is just a motion that's very buzzwordy, but with no substance whatsoever. And that's true also in the response that she puts in now 4 months later. She puts in a response saying, oh, this is, invade my privacy. We're getting directly at, are you still communicating with this boyfriend you say that you've broken up with? That's a domestic violence risk. Those are the things that we're directly driving at. And again, time limited, scope limited, no burden to her. This is not privileged. This is fully discoverable. Discovery and discovery motions are not supposed to be used as a sword, and in this case they are. Is that Mrs. is trying to say, we bring this motion because I don't want you to see what these negative things could be. I don't want you to gain access to these things that would be problematic for your case. Everything that's not privileged is discoverable. And so in this case, they just have no leg to stand on whatsoever. The court should deny the motion and the court should grant fees. This is really a baseless motion, especially when this is targeted, it's direct, it's directly on point within case law within the statute. And at this point it's moot. So then bring it before the court when it's moot. After the fact, 4 months after the fact, there's no basis to have done so. Sorry, I am asking for fees to be awarded.
Any response?
Yeah, in the motion for the protective order that was given, it talks about the subpoena, but it also talks to preclude discovery of phone records involving communications with third parties non-relevant to this action, and to limit the scope of discovery to exclude communications with family members and friends to protect against harassment and undue burden, which goes back to the number 4 request for production that was sent in the discovery. So it's not only the subpoena, but it also is talking about the number 4 request in that discovery. So it does mention it in the original motion that was filed in May.
So again, the court understands that you're not an attorney and all the ins and outs may not be known. The court agrees with Ms. Baldwin in regard to what she said. It was filed in May. We're here in October. It's not brought to be requested until several months later. Meanwhile, in regard to the subpoena that was sent, the court does not find that it was fraud. It had to do with the telephone records. So are you saying that you think that the text messages?
No, the subpoena isn't broad. It's very narrow between the two numbers. It's just that the discovery request for number 4 is overly broad. It's asking for every text message that I've ever received or sent since January 1st, 2022 until that discovery was sent in April of 2024.
When I read the motion, I didn't see text messages as part of it.
I don't believe that they are. Although, because that's, honestly, this is very old.
It was just kind of briefly in the relief requested stated the discovery of phone records involving communications with third parties is relevant to this, and then limit the scope of discovery to exclude communications. So that is talking about like the number 4 request in the discovery where it's asking.
Right, but so if you look at their motion, it's regarding. Okay, I'm happy to address that if the court wants me to.
No. The court doesn't agree that it extends to that. You need something very specific to the text messages, the interrogatories, if that's what you want, and bring a separate motion for that request.
Okay.
Okay,
Yeah,
and the basis for why, legal basis as to why those text messages shouldn't be disclosed. Okay. So in regard to the fees, the court does find and will grant $1,000 in fees for the necessity of having to be here on a motion that's filed back in May.
We can just do presentation on that same date.
60 days, what?
Oh, we can just do presentation on that same date.
That's fine.
On the 22nd?
Yes.
That concludes this docket.